Welcome to the Property PSL audio update for September 2014. I'm Melissa Moore, a commercial property lawyer working in the Property PSL team. For those of you who are Property PSL subscribers, you will know that our property homepage contains details of the monthly highlights. Audio updates are designed to supplement the highlights with a selection of developments over the last month for lawyers on the go. This month we look at cases on restoration and priority of leases, collective enfranchisement notices, VAT on the sale of a property, and human rights defences in private sector possession claims. The first case we consider is Goldharp Properties versus McLeod, where leases restored to the register took priority over leases of the same space. The property in this case was acquired in 1988 by a group of teachers with a view to its redevelopment into 4 flats. The 2 lower floors were acquired in 1999 by a company owned and controlled by a developer. Those floors were converted into 4 flats. The claimants retained title to their respective parts of the roof space. The developer coveted the opportunity to develop the top floor. He orchestrated a sequence of events which he hoped would enable him to acquire the roof space without having to make any payment to the claimants whatsoever. On the 13th of February 2009, his son acquired the freehold of the property. The next payment of ground rent in respect of the roof space, £50 for each flat, was payable on the 25th of March 2009. Payment was not made on the due date, and on the 4th of June 2009, the property developer instructed a firm of bailiffs to effect a formal re-entry, even though in terms of the leases, re-entry could only be exercised when rent was in arrears for more than 3 months. That is, not before the 26th of June 2009. On the same date, the developer made an application for planning permission in respect of the roof space. Unaware of these developments, the claimants belatedly paid the ground rent. They sent a cheque to the property developer's son at the developer's address. The developer was aware of the receipt of the cheque but took no steps to forward it to his son. On the 27th of July 2009, the son made a statutory declaration that the claimant's leases had been determined by peaceable re-entry following non-payment of rent. On the 30th of July, an application was made to the Land Registry for the closure of the claimant's leasehold titles on the basis of the forfeiture of the leases to which they related. The application was granted and the register was amended on the 5th of August 2009. At the same time, the registrar amended the schedule of notices of leases by removing reference to the leases. In the meantime, a long lease of the whole of the roof space had been granted by the son to a company, the sole director of which was a business associate of his father's. The leasehold title was registered with effect from the 2nd of September 2009, and the new lease was entered on the schedule of notices of leases. The lease was subsequently assigned to another company and on the same day to Goldharp. Both the first assignee and Goldharp were owned and controlled by the developer. The Court of Appeal confirmed that the 2 leasehold titles should be restored to the register. They had been invalidly forfeited and they took priority over the subsequent lease of the same space. The effect of the legislation was that the power of the court or the register is not limited to restoring an interest to the register, but extends to changing what would otherwise be the priority as between it and another interest. The second case we look at is Wiggins versus Regent's Wealth, where it was held that there can be no retrospective amendment to collective enfranchisement notices. In this case, the leasehold structure of the property was fairly complex. There was a head lease, a management lease, and occupational underleases of 7 flats. There were also overriding leases of those flats and an enforcer lease above the management lease to allow the enforcement of it, despite the grant of the overriding leases. The initial collective enfranchisement notice specified all these leasehold interests as interests to be acquired, other than the occupational underleases. The initial notice was not registered against the titles of the landlords to the overriding leases of the 3rd, 4th and 5th floor, old leases. Subsequently, the landlords of each of these old leases granted further long leases or new leases which were registered at the Land Registry. The solicitors for the landlords of the old leases claimed that the new leases were not liable to acquisition and that, if the enfranchisement went ahead, the participating tenants would acquire the old leases subject to the new leases, but for a price which disregarded the existence of the new leases. They argued the participating tenants should pay nearly £7 million for the old leases, which now only gave the right of possession for 10 days in 21-22. The participating tenants asked the landlords to agree to an amendment to the initial notice to include the new leases. They refused. Subsequently, the participating tenants acquired the freehold, head lease and enforcer lease. The Court of Appeal decided that an initial notice could not be amended to include leases granted after it was served. As the initial notice had not been registered, the new tenants took free of the enfranchisement claim. The clear message is therefore to ensure that the initial notice is registered to avoid a situation like this happening. In CLP Holding Company versus Singh, the Court of Appeal decided that a buyer was not liable to pay VAT to the seller, even though the seller had opted to tax, as the buyer would not have reasonably understood it was liable to pay VAT in the circumstances. The general conditions of sale could only have one reasonable interpretation. Any liability for VAT should fall on the buyer. However, the contract had to be interpreted as a whole in the light of all the circumstances, taking everything into consideration, including the fact that the special conditions and replies to requisitions on title specified a purchase price of £130,000 only. There was little doubt that such a person would conclude that the parties intended that nothing was or could become payable by the buyers over and above the specified price of £130,000. The circumstances of this case, especially the timeline where the whole purchase price was paid over to the seller a long time before completion, might be unusual, but clearly best practice in all circumstances is to spell out in the contract that VAT is payable. In MacDonald v MacDonald, the Court of Appeal closed the door to the application of an Article 8 of the European Convention on Human Rights defence against a claim for possession by a private landlord. Miss MacDonald had rented a house from her parents under an assured short-hold tenancy. The parents had fallen into arrears on the mortgage and the lender appointed receivers who then issued a possession notice. A possession order was granted and Miss MacDonald appealed. Since the decision of the Supreme Court in Manchester City Council versus Pinnock, it has been settled law that in cases involving a public authority landlord, a tenant can rely on Article 8 and have the proportionality of a possession order tested by the court. However, their lordships in Pinnock did not answer the question of whether Article 8 could be used against a private landlord. In this case, the Court of Appeal was given the opportunity to answer that question. The Court of Appeal unanimously dismissed the appeal. They could not find any European jurisprudence in support of Miss MacDonald's application of Article 8 against a private landlord. Even if there had been case law to support her, the court held the rights of Miss MacDonald would not outweigh the rights of a private landlord to their property. In any event, the Court of Appeal were bound by their earlier decision in Poplar Housing and Regeneration Community Association Limited versus Donoghue, where it was held that Section 21 of the Housing Act 1988 was compatible with the Convention, precluding the application of the proportionality test. This last month, we've developed some really good new content on our PSL website. Have a look at the various enfranchisement checklists for tenants in requesting new business tenancies, and on the numerous new questions and answers. Thank you for joining me.